he says, this is right, that if there's a coin flip, I'm going to be really bothered by this. This is problematic. We can't just go around convicting people based on coin flips, right? And so there he suggests he would think it appropriate for the court to step in. But you said a moment ago that he ultimately concludes this is a non-justiciable political question, namely, what is or is not a trial. So how can we reconcile those two positions, or can we not?
If your perspective is Roe in the trimester framework, then Casey is a profoundly conservative decision because it got rid of the trimester framework and has opened the door to what we see today, which is just constant whittling away attacks on the abortion right, whittling away of abortion access, because that's essentially what Casey allows. It allows for regulation of the abortion procedure throughout the entirety of pregnancy.
And then I guess I'll add a third question to that, which is sort of the big picture question, which is we're dealing with a technology that's changing rapidly. In 1996, it was basically unheard of to have these computer-generated images. Today, it's not unheard of. Today, it can happen. And today, the technology is changing incredibly quickly. Now it's possible to have realistic computer-generated images, both still images and also videos. Some of you may be familiar with deep fakes, this idea of artificial intelligence used to create realistic video images where it's like a face on someone else's body and it doesn't fit and it's weird and you're like, what is going on? What dystopian world are we about to enter? And that has potentially important implications.
That jumped out at you, be distressed. We can talk about it. It's hard to figure out where it fits in a legal analysis, but one certainly could. By talking about the way the rules are going to be applied and who's actually going to be harmed. Mass incarceration is not a phenomenon that rich white people are adversely affected by, at least in their personal lives. So we will see that often implicit rather than explicit in civil procedure, but I think it's important to know.
The complication even at that point, right, even in the era of AOL, is what they refer to as click-through access, right? Your ability to go beyond AOL's walled garden and into the rest of the internet. And so the question is, when cable modem service, or even when AOL lets you go beyond that walled garden into the rest of the internet, is what they're offering you mere transmission of information that you choose from Google to you, from Netflix to you? Is it just the transmission of that information? In which case, it would be a telecommunication service, or is it also an information service?
So there are two different interpretations of arising under federal law that are at work here. It's not that one is right and the other is wrong, or that you're crazy, or anything else. It's just that the Supreme Court is saying, in one context, a particular phrase means one thing, and in a different context, it means a different thing. You might be confused because those contexts seem awfully close to each other. And it seems kind of weird that the Supreme Court would say the same language means different things. But get used to that.